video of my podcast, The Judge's Oath. Today I'm going to talk about a Substack article I have called AI and the Self-Represented Litigant. Will AI help the common man who can no longer afford legal representation at the cost of $350 to $450 an hour? This is the question. As AI becomes more usable for legal research, organizing facts, understanding terminology, drafting motions, and locating authorities, more people who normally could not access a court can now more easily represent themselves. However, I argue in my book, The Judge's Oath, that our legal system needs to be reformed because it no longer works for the common man, even with AI. The important barrier topics include experts in discovery, settlement, and the attorney conflict of interest, the American Legislation Council, Exchange Council, or ALEC, judicial bias, the courtroom, financial burden, false arguments about AI, and digital forensics. Experts in discovery. I attempted to hire ABC Legal to deliver subpoenas for my case, and the person being served had moved. Then I discovered that even though ABC Legal has a service to locate a party, they would not provide that service to me as a pro per litigant, even if I took legal responsibility for the information and/or declined to take possession of information used to locate that person. This is bias per se against the proper litigant in our courts. Yes, many experts do not work with self-represented litigants, and generally the costs of experts have elevated prices for their work. For example, the cost for a deposition is now almost $3,000 for a day, which cannot be avoided. It is required to have a court recorder give your witness the oath and then certify the video or transcript. Therefore, if a self-represented litigant cannot access experts for their case probably won't be successful, depending on the causes of action. Settlement and the attorney conflict of interest. The problem is if the attorney settles for a reasonable payout up front, they don't get to line their pockets with insurance money for litigation. The attorney must litigate to make money versus settling for their client for a lesser amount. This conflict makes settlement almost impossible. The American Legislation Exchange Council, ALEC, is an organization that has been pushing for legislation to deprive the common man with access to our courts in many ways, such as removal of the right to a jury trial, removal of the right to discovery, removal of the right to elect judges, tort reform against injured Americans, guns, prison, crime, and immigration reform, worker and consumer rights, and the use of a lifetime government defamation to remove access to the court for the self-represented litigant by deeming them vexatious. It is used to stop a person from litigating when they cannot pay a security deposit of $15,000 and when pro per cannot afford an attorney. The standard is that they only have to lose 5 cases in 7 years, even small claims cases. In 2011, California's government defamation statute against the self-represented, CCP 391, was perverted to a dangerous degree. In contrast to past legal precedents, CCP 391 now includes small claims cases dismissed without prejudice, which means a plaintiff can sue the same parties for the same causes of action within the statute of limitations. In other words, it means a plaintiff probably met their legal burden versus dismissed with prejudice. Repeatability was changed to 1 from 12 to 20, and evidence was routinely hidden and ignored from the court docket. i.e., hidden from the public. Plaintiffs are punished and damaged for life simply for using the court just as much as a wealthy person would who could afford an attorney. Judicial bias. And court judges appear to assume the attorneys are truthful and the pro per the liar, which is generally the opposite. One of the most persistent issues is that judges, attorneys, and court personnel view self-represented litigants as less credible, less prepared, more emotional, and more likely to waste the court time. Even when a self-represented litigant presents a legally sound argument, the court interprets procedural mistakes harshly. I argue that currently the bias against the self-represented litigant by the judicial is profound in favor of well-connected attorneys. I provide examples on my website, www.thejudgesoath.com, that judges do the work for attorneys. They ignore and hide evidence for them and pervert the law for them. They also allow the well-connected attorney to lie boldly with no evidence. Why aren't the licenses of attorneys affected when they boldly lie? An attorney is more likely to lose their license for speaking truth to power than they are for boldly lying to the court. For example, Stephan Jacobson argues that I have been domiciled in Oregon since 2023 with no evidence. But why would he lie so boldly, knowing that this is untrue? His clients of Berg's even state on their TikTok account that I've come and gone and monitor me 24/7 with a camera 24 feet high on their garage. So they know the truth. Why lie when it is so easy to prove false unless they think the judges are in their pocket and they can boldly lie with no consequence? Another example is the Santa Barbara tax assessor, which I have a full video on. But briefly, I'll summarize, and I have the video in my Substack, but I'm going to go offline, not reading from my Substack article, and briefly summarize my video. Basically, first, when I sold my house on the Mesa, which broke my heart, um, I I took it out of an irrevocable trust, which was in an irrevocable trust because of Sam, which is what I talk about in my book, The Judge's Oath. And I took it out of the irrevocable trust during COVID, 2 weeks after Prop 19 was put in effect. And Prop 19 was passed during COVID, so people weren't paying attention. And it's designed to take away people's Prop 13 rights, which of course is it keeps your property tax based on stable for the same as when you bought your property. And so I was looking at possibly doing a 1031 and selling because I thought I would get fired because I didn't take the jab during COVID. And so I opened an envelope and found out that my property had been reassessed 2 years earlier in 2021. They claim they notified me, but there is no legal requirement that they prove it, that they send you certified mail or something that would get your attention, which I argue in my book for court reform that they should be required if they're reassessing your property to notify you with certified mail or something that will get your attention, because I don't ever remember getting anything in the mail stating that my property had been reassessed and went from $8,000 a year to $20,000 a year because I lost my Prop 13 rights. And Prop 19 has crazy requirements, like your beneficiary has to live in the home for a year after. So because I wasn't notified, my son didn't live in my home, I didn't know, and I couldn't go back and cure it. And in contrast, I found out when my son's father, Eric, died, um, his he had an apartment complex a half a block from UCSB, completely paid for. And my son has not been benefiting from this. He's my Eric's only child. So I did some research and discovered that this alleged trustee and attorney, I was told it was Eric Babion, but I have out of Woodland Hills, but I haven't confirmed that. And he filed a document on November 20th that Eric was the trustee of his apartment, my son's dad. But the weird thing was, Eric died on November 2nd. So why is this trustee filing that a dead man is the trustee? So I think the reason is because this apartment complex is residential because it's only 4 units. Therefore, to keep Prop 13, you need a parent-child exemption form like I did, and you need to submit the trust like what Santa Barbara tax assessor told me I had to do. And by him stating that a dead man is a trustee, he's escaping the legal requirements. A legal requirement also is that you identify that you're the trustee. And the politicians have told me, oh, you need an attorney. Well, the tax assessor didn't need to hire an attorney in my case when they didn't even tell me about it for 2 years. And dad felt like I had to sell, which broke my heart. And I gave a certified death certificate to the Santa Barbara tax assessor, and now a shout out in my video. Why are you treating this attorney about who's above to be above the law? In contrast to how you treated me, so he could steal my son's inheritance, an apartment complex that's making like 20 grand a month and it's not being maintained. Where's all that money going? So I'm not fond of attorneys, as you can imagine. But going on and reading my article, so how can we expect to have a chance? It appears today that the role of judges is to ensure that attorneys in a legal machine make the money, suspecting that the judges get paid under the table for their biased opinions. The courtroom. Challenges include examining witnesses, objecting properly, preserving the record, responding under pressure, reading jurors, knowing when not to argue, and handling questioning. Therefore, a person can have an excellent AI generated brief and still struggle in live proceedings. Financial burden. The financial burden placed against a self represented litigant who can't afford an attorney generally is overwhelming. They face a well-funded opponent with multiple attorneys, paralegals, investigators, expert witnesses, and more. And this is the reason the divide between the have versus the have-nots has widened to a dangerous degree. In real estate, the way the system is set up is that if you are a realtor or a seller and are sued as defendants by buyers who were ripped off, the realtors and sellers as defendants receive help by their insurance company, but the buyer receives no help as a plaintiff. And 95% of real estate lawsuits are filed by buyers. So the legal system is set up against buyers. The common man no longer has redress against the well-connected. Abuse can be rampant, and yet they are the ones punished if they attempt to ask our courts for help to resolve matters peacefully. False arguments about AI. One attorney, Aaron Hissel, argues that the self-represented litigant may invent a deposition with AI, which is not valid because one has to hire a court recorder to administer the oath and to certify your video recording and transcript for it to be admissible in court. Of course, he made this argument to create hardship for the litigant who cannot afford an attorney and the cost of litigation. The well-connected attorney knows that depositions in person are more expensive than remote depositions because you don't have to pay for a conference room or hotel, transportation, and more. Digital forensics in the era of AI. As AI rapidly advances, I argue that digital forensic has become one of the most important disciplines in modern litigation. Artificial intelligence is now capable of generating highly convincing photographs, videos, audio recordings, emails, text messages, contracts, and other digital documents. Because of these technological advances, courts should no longer assume that digital evidence is authentic simply because it appears genuine. I contend that digital forensic experts will become increasingly indispensable in authenticating evidence presented in court. Their work extends far beyond simply recovering deleted files. Metadata often provides the most reliable evidence available, which include file creation dates, modification histories, GPS coordinates, device identifiers, operating system logs, cloud synchronization records, browser histories, deleted files, and user activity logs. Frequently reveal facts that are impossible to determine by merely looking at the document itself. Digital forensic is equally important in recovering evidence that parties claim have been deleted. In many cases, the attempt to destroy evidence may itself become powerful evidence. A party has the burden of preserving evidence once they know a lawsuit is imminent. It is a crime to engage in evidence spoilage. Self-represented litigants should educate themselves about digital forensic before filing suit. Experts vary greatly in qualifications, specialties, and costs. Some specialize in computers, others in mobile devices, cloud storage, financial records, surveillance systems, or video authentications. Prices vary widely, making it essential to compare credentials, experience, and fees before retaining an expert. For the self-represented litigant, AI will increasingly open doors with the responsibility of ensuring that the cases, rules, evidence, and facts that AI provides are correct. Please subscribe to my Substack, like my videos. I really appreciate it. It helps us to have a discussion that nobody else is having, which is specifically regarding court reform and the self-represented litigant. And have a great day. Thank you so much for watching. Bye.